After 5 weeks of gut-wrenching testimony, guttural sobs from the defendant, and an overdue conversation on postpartum mental health that has dominated social media, the, quote, saddest trial in America is finally nearing its crucial finale. Both sides in the first-degree murder trial of Massachusetts mother Lindsay Clancy have now officially rested their cases. Pivotal closing arguments are set for tomorrow. Lindsay Clancy, the once doting mother, admits to strangling to death her 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan with exercise cords in the family's basement in January of 2023. She then tried to kill herself, slashing her wrists and jumping headfirst out a second-story window. She lived, but is paralyzed from the chest down. Clancy's defense says that she killed her children in a bout of rare postpartum psychosis. She says she was literally out of her mind and therefore not criminally liable under Massachusetts law. The defense has called multiple witnesses who testified that Clancy desperately and repeatedly sought help from mental health providers as she sank deeper into crisis. But instead of helping, the defense argues those professionals failed to see the seriousness of Clancy's condition and may have even made it worse by over-medicating her. Prosecutors have paraded their own witnesses, psychiatrists and psychologists, all trying to chip away at that defense argument that Clancy couldn't tell right from wrong and that she was consumed by a male voice commanding her to commit the worst act imaginable. Was Clancy depressed, suicidal? Yes, prosecutors argue, but they contend her behavior does not align with known symptoms of postpartum psychosis, a point the prosecution's last witness, a senior psychiatrist with the FBI, sought to drive home today.
Throughout the day, I mean, she was methodical and quite controlled and organized, even in that space of time that was short. There was a lot to do in terms of killing her children and also killing herself. It is my opinion within a reasonable degree of medical certainty that Ms. Clancy was criminally responsible.
But defense attorney Kevin Reddington pushed back, reading back the prosecution's own opening statement from just 1 month ago and prompting the prosecution's own witness to make this bombshell admission.
She chose to manipulate her providers, seek out a quick and easy fix when she was feeling depressed and anxious, and after only 4 months in treatment, she made a choice. A deliberate and intentional decision that she did not want to try anymore. And because no one could take care of her kids the way she wanted them to, she had to take them with her too. Would you agree that the evidence, in your opinion, supports that contention, sir?
I think that statement that you read really minimizes what she was going through.
In a final move before closing arguments, the judge this afternoon agreed to allow the jury to consider convicting Clancy on a lesser charge of manslaughter. That was a big win for the defense. Let's bring in our panel, who by now is well-versed on the intricacies of this trial, former federal prosecutor Nima Rahmani and criminal defense attorney Brian Claypool. Nima, let's first start with that moment we just played. Did you find that powerful when the prosecution's own FBI psychiatric, expert witness, after being read back the prosecution's own opening statement, says, yeah, that's not quite accurate?
I thought it was very powerful, and it's also powerful when the defense attorney stops his cross-examination on that question. That's really a drop the mic type of moment there. And really, I think the prosecution really pushed this case too far in terms of two things. One was the manipulation of the doctors. That's something that shouldn't have been said in opening statement, as well as throughout the trial. This argument that maybe she was exaggerating her attempted suicide. I think you lose points and credibility with the jurors. I mean, it's clearly she's there, she's suffering, she's paralyzed, she's in a wheelchair. So sometimes as a prosecutor, you get so caught up in a case, you're working on it for months, months, sometimes years, and you really lose the sight of the forest from the trees. And that's how you can turn off jurors. So I think the expert witness here actually did the right thing. You have to hedge a little. And he essentially said, look, she's mentally ill. It's clear, but that doesn't mean she's legally insane. They're two very different things. And I think that's the proper balance you want to take, whether you're a lawyer or you're an expert witness. And I think the witness got it right here.
So very quickly, before I turn to Brian, do you think the prosecution managed to clean it up with this last witness? Are they now, I mean, how are they making that argument compellingly enough? Because up until this point, many, including yourself, a prosecutor, were critical of the way they were presenting their case and didn't think they were going to win this thing.
Elizabeth, I think they cleaned it up, but I think there's still a problem. Look, this witness did a good job saying two things. One, the voices not really reliable because it was intermittent. So that gets rid of one of the components of criminal responsibility. The other is that she could control her actions. The problem with this case, Elizabeth, is you have two reasonable explanations, right? And we've spent so much time talking about reasonable doubt. And there's going to be a jury instruction that says if there's a reasonable explanation for the defense,
figure it out,
you can't figure it out, a tie goes to the defense because the prosecution has the burden. I think that's the fundamental problem in this case, that there are two reasonable explanations here, and reasonable minds can differ, which means reasonable doubt and a not guilty or not criminally responsible.
Brian, meantime, the defense I think it's a pretty big thing when the judge agreed to allow the jury to consider manslaughter. The prosecution argued against it. They've been going for first-degree murder, but all along, it's been hard to understand their first-degree murder. In other words, there were many witnesses over many months who said she was suicidal and saying she had, disturbing thoughts of harming her kids and calling suicide hotlines. And you begin to, is the prosecution's case that she was planning all this, the murders all along? How big a deal is it that the jury will now get to consider manslaughter?
Hey, Elizabeth, nice to see you again. It's a huge deal. What do I mean by that? People need to realize that big trials like this are won or lost a lot of times when you and I and Nima are not seeing live testimony. It's the discussions that are taking place outside the presence of the jurors, where the judge and the lawyers are talking about what are the jury instructions, what will they be, what will that verdict form say, for example. Cases can be won and lost there. And I think what the judge did here is he threw the defense a bone with voluntary manslaughter, because I personally think that he improperly stated the definition of insanity for this verdict form. I don't think it's accurate. He said, unless I'm wrong, you tell me, I think he said you can find her insane if she was suffering from postpartum psychosis. That's not the law. If he said that, that's not the law in Massachusetts. It's a level of impairment that substantially affects your ability to appreciate the wrongfulness of your conduct. And why is that important, Elizabeth? Because you could have some jurors over there saying, oh, wait a minute, I think she was bipolar, I think she was suicidal, but that's not postpartum psychosis. Therefore, I can't find her legally insane. So I think the instruction he gave on that is inaccurate and is going to create confusion. And because of that, that's why he threw in the voluntary manslaughter.
Nima, what would you, if you were prosecuting this case, I know you wouldn't have made the mistakes you think the prosecutors have made thus far, what would you do when you're in front of that jury tomorrow morning for closing arguments? What would you say?
Yeah, I would be frankly happy with any type of conviction here, because I understand why they're prosecuting this case. You can't just walk away from a mother that kills three of her kids. So there's a lot of political pressure. But if you're looking at the different degrees here, right? First degree Massachusetts, most states, premeditation. Also in Massachusetts, if there's real cruelty or atrocity, which you get here. Second degree, of course, is your malice murder, your intentional murder. Then you start getting into manslaughter, which it's not what you typically see. It's criminal recklessness, right? Or sort of the heat of passion. You walk in on your spouse. So it doesn't really fit here. But look, what's justice? It's a potential 20-year sentence when she's going to very likely get either not criminally responsible or a hung jury. If you can get manslaughter here, even though it's not what you want, if you're the prosecution, it's probably a win. Usually prosecutors, they don't like these lesser included because it allows the jury to reach a compromise verdict that really prosecutors don't like in murder cases. But when you have a weak case, it may be throwing you a lifeline here that otherwise wouldn't have existed if it's an all or nothing.
All right, it's going to be a very, very big day. I'm sure we will talk to you about it. Closing argument set for tomorrow morning. The jury could get the trial and begin deliberations by tomorrow afternoon. Nima Rahmani, Brian Claypool, thank you both so much. Appreciate it.